Um, Mr. Chief, I will just check for us whether they were speaking the SEA already. And you say Judge Majid is compromised. Can you elaborate?
Well,
Compromise,
sorry.
please.
Sorry, I apologize.
Compromised his independence for personal gain. That's what you say of a colleague in another court. Tell this body, compromised his independence for personal gain. Everything that he said there, justify it?
No, I cannot justify it. I apologize for it.
But why did you say it?
As I've indicated,
to Professor Mutala, to an outsider. If I say outsider, I mean to not even to another judge.
As I've indicated, at the time we were friends. We discussed many issues. If you look at his emails, which are attached, he also made some spurious remarks about other judges. So we discussed it as we often did, in a very heated way, in a very robust way. But I considered it to be personal communications between friends at the time.
But you are not attacking Professor Mutala. You attack third persons.
Yes, with hindsight, I ought not to have done that.
And now, do you still hold those views concerning Judge Majid, that he compromised his independence for personal gain?
No, absolutely not. In fact, since that first draft that the Western Cape High Court objected to of the norms and standards, the final product of the norms and standards has been much improved, and we were very happy to see that a lot of our objections and criticisms were in fact taken into account, as well as objections of other divisions, and the final product is really very workable. And at some point hope I have the opportunity to elaborate what I mean by that. But I find the final product of the norms and standards is very productive for the administration of justice. And in fact, the committee that eventually, whose members are criticized here, obviously eventually were instrumental in setting up the structures we now have, which is the NEEC and the PEEC, and of course the regional structures, the REEC. And they are working, I can see the wisdom in them now, they are working very well. And in fact, it is not merely a matter, as I said, of unblocking the log jams in the system and identifying the difficulties with the administration of justice and the service delivery. But I've also come to learn, as a result of discussions with none other than Judge Nathan Erasmus himself, that in fact it is a situation where other stakeholders on those committees are being called upon to intervene logistically in areas which need urgent attention. For example, I understand that in a particular area in the Western Cape, the Domestic Violence Court, for example, received something in the region of 10,000 complaints over a limited period. And that spoke volumes of the fact that there was some serious social, economic problems going on in a particular area in the Western Cape. And as a result of us having a PEE structure, as a result of us having an NEE structure, which was set up by this very committee, not only could there be judicial intervention to assist that court, namely the Domestic Violence Court, but you could also have social development who are representatives on this PEEC paying attention to the problem there, and they could actually send social workers out into that particular area to establish. So I see the wisdom of that, those committees suggested at the time. My greatest difficulty at the time was the way the norms and standards was initially drafted. It did not seem to be capable of practical implementation, but also because we, as the Western Cape High Court, had already been implementing a lot of the initiatives suggested. In a way, as I've indicated, we already had, for example, a list for reserve judgments. We already had case flow management. And at the time, many of us, and I myself, felt that perhaps the norms and standards, the way they were structured, was unnecessary because we were already implementing all of that. Yeah. I've subsequently come to realize the wisdom in it, that it in fact provides consistency for the entire country. I had no idea as to the difficulties that was being experienced in the other divisions, and I was thinking purely from the perspective of what our lived reality and experiences were, and I thought we were working fine the way we were. But I've subsequently come to realize that there's great benefit and virtue in the structures that were set up by these committees. So indeed, the criticisms were, Professor Mutala's criticisms were heated. They angered me. They were unfair. And I then responded likewise in an unfair and intemperate way. And I apologize for that.
Yes. Judge, I don't want to interrupt you because sure. I'm not the chairperson. If I was, I would have tried to say to you to be as brief as possible.
All right.
So that for the sake of progress. But Judge Ali, if Judge Majid compromised his independence for personal gain, would he be fit and proper to remain a judge? Should he then not have been reported to the Judicial Conduct Committee? And I'm just rolling this up. The same with Judge Erasmus, so that they can explain themselves, complain to the Judicial Service Commission about these people. Did, firstly, maybe in fairness, would they be fit and proper people to remain judges? What is your response?
If my allegations at the time were correct, then probably the correct thing the correct thing to have done would have been to report them, but then one would have had to have evidence of that. As I've indicated, I was really just reacting in anger to the unfair criticisms that was leveled against the division. As I've indicated, I do apologize for that. I don't believe that those criticisms were, that my comments were correct. I still don't believe they are correct.
Okay, let's make progress. Chris Govender, who overtly supported Binsworth's appointment at the Judicial Service Commission. Binsworth is now a judge and a colleague in your division?
That's correct.
So what are you saying? Are you saying that Judge Binsworth should not have been appointed, and because Chris Govender, who is a very experienced attorney, I know, I served with him in Adel, should not have supported him? Tell us.
No, I'm not saying that. In that sentence, I'm merely stating who the members were of the committee that I'm aware of, and what I know about them. I'm not stating that anything about Judge Binsworth other than what I knew at the time was that Mr. Govender seemed to be overtly supporting him. Nothing more than that. There's no imputing of any impropriety to Judge Binzhood, certainly not to Mr. Govender. I'm merely sketching for the benefit of somebody who wasn't in South Africa and I thought was making a rather ill-informed attacks on the Western Cape High Court as to what information exists that is known about the people on the committee whose work he appeared to be defending at the expense of criticizing the Western Cape High Court unfairly. There was no intention to in fact say anything negative about Judge Binzhood. In fact, we work together on committees and we sit together in appeals and other matters. So, but once again, I can only repeat what I've said previously, that I don't hold any views of a negative nature. It was factual, but it wasn't meant to humiliate or insult the judges concerned.
Yes, in the interest of time, I'm skipping a number of things, but the following day, I'm now in the fourth paragraph of the same page at 12:16 a.m., February the 20th, you write, and thus, in quotes, open quotes, striving to curtail fruitless and wasteful, close quote, expenditure, close quote, include the CJ, which means the Chief Justice, and his undemocratically appointed group of judges trip all over the world to investigate different models. Does it include TGE? What does that mean?
I think it's a typographical area. It is supposed to mean the.
Huh?
It's supposed to be the.
Oh, okay. Oh, does it include that Chief Justice, 8 bodyguards, many cars, and extravagant conferences at which the entire Hertz fleet had to remain outside the hotel with drivers in case any of us needed them while in conference, and the ER24 personnel living and eating in the hotel with us in case of any of us have a headache. We've been working for years with inadequate resources, and so the proposed norms and standards presupposes a full functional high-speed internet, intranet, and e-library, sufficient properly trained researchers for each judge, and not just at the Concord, and properly skilled and trained PAs. I want to stop there. You're now talking about the head of the judiciary in terms of the Constitution and the Superior Courts Act. This is what you're saying about the head of the judiciary. What do you want to say about this?
Well, the words in inverted commas, striving to curtail fruitless and wasteful expenditure, was part of the norms of the original draft, or the first draft of the norms and standards document. And what I was trying to convey to the professor was that if we're going to have to curtail fruitless, wasteful expenditure, then we must also be even-handed about that and consistent about that. And one must, in fact, curtail fruitless and wasteful expenditure everywhere. The reference to trips to different parts of the world, in fact, in the meeting or after the meeting we had with the Chief Justice, at which we presented our objections, which Professor Mutala accused or labeled as racist objections. We in fact discussed with those same judges who served on the committee outside about we questioned the need to go and investigate other case flow models in other countries, whereas we had sufficient and good enough best practice right here in South Africa. And so it was not a secretive conversation, it was part of a debate amongst judges about whether, in fact, the decision to go and investigate other models in other countries was a wise decision at the time. So I was linking that to the need to curtail fruitless and wasteful expenditure. I was doing the same with regard to a conference. It's not a conference that was actually organized by this Chief Justice, but I think it was a conference organized by the previous Chief Justice, at which this Chief Justice was obviously present and involved. At the conference, I must say that I did find it strange that there was this huge amount of drivers and cars available throughout the operation of the conference, not just to drop us there, and also the ER personnel who were there in case we needed any assistance, and we're talking about a fair amount of them in the hotel. At the time, I did consider that also to be wasteful. So I was trying to, I was trying to convince the professor that this issue is actually not as he may see it to be, that there are more issues that we must be consistent and in curtailing frivolous and wasteful expenditure, to the extent that he appeared to be defending the initial draft. And if you look at his emails, he even suggests that the initial draft of the norms and standards was what he conceptualized as long ago as 2001, and he mentions in his emails all the different heads of the judiciary that he had tried to convince to implement these norms and standards previously since 2001. So to my mind, it seemed as though he was taking ownership of the first draft of the norms and standards, and I was criticizing aspects of it with him to the extent that he appeared to be taking ownership of those norms and standards, saying that he mooted the idea with members of the judiciary as long ago as 2001. He continued to do so.
Yes, I want to end up with the last quotation. That would be a page, which would be the fourth page. You just page over, and that it's under the paragraph. The time would be 12:19 on the 20th of February, and that is the last paragraph. Dalla was known for his chronism. My kids must pull themselves up by their own bootstraps. I will never use my relationship contacts with people to advance them. In principle, I would die for.
It's a principle.
Well, it's a principle I would die for. And then I'm aware that there is a need for norms and aspirational values, but not in its current form. It's a sick roadshow being conducted by an individual with no conviction or insight. History will vindicate us on this. It's an individual with no conviction or insight. Who is this individual who has no conviction or insight? Who is this?
The individual really is Professor Mutala, because he took ownership of it. To the extent, as I said, he took ownership of it, and he was prepared to, in fact, go out batting publicly for it and unfairly criticize our objections to it. And the reference to the other aspects that you read, I don't know if you want me to address those. Professor Matala is
But
not
really
here to defend himself, so
Sorry,
I'm reluctant.
The question was who this individual is, and you say it's Professor Mutala.
Yes, it's Professor Matala, because to the extent that he's taken ownership of it and he's going out in the media batting for it.
Judge, just look at the context. It's a Sikh roadshow being conducted by an individual with no conviction or insight. Is Professor Mutala conducting this Sikh roadshow?
Well, to the extent that he was going in the media, in fact, had a follow-up op-ed piece also on it, and he was in legal brief on it. What he was doing is he was obviously conducting a media campaign for it, and as I've said, he's taken ownership of it, and said that this was his idea as long ago as 2001, and he mentions all the different individuals in the judiciary that he has tried to get to buy into the idea. He was effectively running a media campaign and putting us in a position where he was suggesting that he was unfairly criticizing our objections to it. So to that extent, I considered it to be, he had no insight. I was trying to give him insight. By that time, on that page, I'd already sort of given up trying to give him insight into it, because he was coming back with answers which was just more of the same criticism. And he was running it as a media campaign. Probably the word roadshow is not correct. It's more media campaign.
Okay.
Yes. I'm concluding, Judge, but I don't want us to leave here without suggesting to you that the person you're referring to here is the Chief Justice, with whom you have to work as a senior judge if appointed a deputy judge president.
Oh, in the context of that paragraph, is that what you're saying?
Yes.
Okay, if you can just give me a minute to then consider the paragraph in its context. Because I was referring to cronyism, I was referring to what Professor Mutala had said about how he got to start his program, his academic program, after consultation with Dalla. So I initially understood what I was saying there to be, I was speaking about Professor Mutala. Then when I was speaking about my children, I was also speaking about Professor Mutala and the favors that he asked of me concerning his child. And then, so I thought the whole paragraph, but if you read it in the context, then it could also be interpreted as being, yes, the word roadshow, it would seem to indicate that it is a reference to the Chief Justice.
Okay. You say you apologize to these people. You have named them in these WhatsApps and emails and so forth. Have you written to them to tell them you apologize to them, or have you told them that you apologize to them?
No, as I've indicated at the beginning, in fact, I considered this to be personal, private text messages between friends. I did not expect that it would be made public. It would have remained something that I said to Professor Mutala in the heat of the moment, and I thought it would end there. 2 years had lapsed, and I assumed that with the passage of time, that's where it would remain, that Professor Mutala would continue as before, and I would continue as before, and whatever heated exchange, but as you know, you've only read out what I've said and not what Professor Mutala has said. So. And there's always a context to everything. When my reference to children and to his children there's also a context to it. But he's not here to defend himself, so I wouldn't want to go into that. But I do want to say that there's a history. When friends become angry with one another, there's a history. It never just arises, and it didn't arise only at the start of these communications. So it was an argument, as it were, between people who were friends at the time. And I did not see my communications with him as being, all my other communications with him as being in a capacity as a judge, but just in a private capacity as a friend who shares some common
I'm sorry, Judge Ali,
values.
I'm sorry you've been there. I think the question was simply whether you did or didn't.
No, I did
apologize
not,
and-
because I did not expect that it would become a public information.
Thank you, Chairperson.
1, 2, 3, 4, 5, 6, 7. We've got 7 names. Commissioner Fourie?
Thank you, President. I've been mostly covered by Judge President Homo. I just want to refer you, Judge Ali, to 2 short other quotes from the WhatsApp correspondence between yourself and Professor Motala, and then just ask you 2 questions thereafter. The paragraph that Judge President Homo read from, starting with thus striving to curtail fruitless and wasteful expenditure, starting with that, he read most of the paragraph except the last sentence. The last sentence says, "The Minister is not making that type of funding available to the Chief Justice who, if current and past extravagance is an indicator, will not manage those resources for the improvement of our infrastructure." Do you stand by that statement?
No, of course not. As I've indicated, what has subsequently transpired in the years that followed on that is that we've seen tremendous improvement in the structures and the infrastructure created.
Okay. Then further down on that page, at 12:34, there's an email, WhatsApp by you saying, "I'm going to send the CJ an email now demanding an answer to that question. Thanks for the heads up. I'm no Griesel, Gauntlet, or any individual whose guilt for political indiscretions can be exploited. I'm no armchair strategist. I'm going for the jugular."
Yes, I was very angry at the time. What I was, sorry, are you
No,
Yeah.
you can answer
what,
to that.
what I was saying to him is, it's also reference to his previous media critiques. Besides critiquing Judge Griesel unfairly, as though he was the sole draftsperson of those criticisms, he's also critiqued Advocate Gauntlet and others in the media. He's very well known for his op-ed pieces in the media. And so I was saying, to the extent that he seeks to exploit those individuals' political indiscretions, I'm not going to succeed in doing that with me, because I am not someone that was not involved in making a difference in the profession and on the bench. So I'm not an armchair person. And I'm going for the jugular. It was a reference to going for his jugular, literally, because I was angry.
I won't debate that with you, but let me just put it to you, because that is my impression. My impression is that your gripe is that what you regarded as personal exchanges landed in the public domain. Your gripe does not seem to be the contents of those personal exchanges.
Could I comment on that?
You could comment on that.
All right. There are many aspects of these personal exchanges, particularly the ones which criticize colleagues, or the one which mentions colleagues in a bad light, the ones which mention individuals in a bad light, the ones which say that the resources will not necessarily find their way into improving our infrastructure, that I regret. Indeed, I regret. I don't stand by them. At the time, I was angry for Professor Mutala. I thought he had been through lots of debates with me and other colleagues, and he ought to know better than to criticize us in the way he did. But I don't, and I readily concede that a lot of the content was a heated exchange, and a lot of them was incorrect, and I've stated as much, so I don't stand by every single aspect. Yeah.
Professor Mutala thought it wise to refer this to this commission, and he says, these exchanges, I believe, demonstrate that Judge Allie does not have the gravitas, maturity, or temperament for the position of Deputy Judge President. What do you say about that?
Yes, well, I disagree with what he says there. My debate with him was a heated one. It was a robust one. It was having felt that we were being unfairly criticized as the division. In a misguided way, it was me coming to the defense of the judges in the division. I do have the temperament required to be a deputy judge president by virtue of the fact that I am able to assert myself when necessary, but I'm also able to make the necessary concessions. I am able to grow and develop in as much as any other deputy head would be able to grow and develop. When it comes to the temperament required in dealing with colleagues, as I've indicated previously, I have a history of dealing with colleagues in the division in a fair manner, and I'm sure I'll be able to do so.
Because of other commissioners waiting to ask questions, I'm not going to pursue the matter further. Just to place on record that, for example, my colleague Krish Govender never served on a committee that prepared the norms and standards or the draft thereof.
That is, I've subsequently found out.
Thank you.
Yes, colleagues, I want to believe that virtually all questions relating to this document have been canvassed, and I want to implore you to try and get ahead to questions relating to the position of DJP that the candidate is here for. Mr. Nyambi.
Thank you. Do you believe that a judge must always discharge official duties, act honorably, and in a manner benefiting judicial office?
Yes.
Do you think we have done that given all what was raised now? I don't want to get to the details of it.
I have always discharged my duties honorably. I've always acted honorably. I acknowledged in these messages I behaved in an emotional and angry way, and that if I had behaved in this way in the course and scope of my employment or in my capacity as a judge, then I would not be fit to hold office, but it was a personal, private argument between two friends.
You are the one who dealt with the case of, may his soul rest in peace, Honorable Ambrosini versus the Speaker of the National Assembly.
That's correct.
Can you quickly summarize for a layman the verdict of the Constitutional Court so that we can understand it?
Those are not one of the cases that I think I presented. I would not have it on the top of my head exactly.
Just the summary of the judgment, your interpretation of your understanding of that judgment.
I'm not sure that I can recollect it. I know the matter was about the procedure adopted in debates for the passing of a private member's bill. And I know the Constitutional Court overturned my decision and found that, in fact, the procedure had to be altered, changed, and it was, in fact, subsequently changed. I'm sorry, but I don't recall the details of how it was to be changed. But they found that it, in fact, was not in accordance with the Constitution. The procedures as it existed was not in accordance with the Constitution.
Let me get it correct. Are you saying after it was changed, you never tried to familiarize yourself with the judgment?
No, I did at the time. It's been some time ago, though I've been doing a lot of other judgments since.
Your understanding of judicial accountability, share with us your understanding of judicial accountability.
Well, judges ought to be accountable, firstly, in the conduct of their work, and they ought to be accountable to the judge president and then ultimately to the Chief Justice. Of course, if judges are found to be incapacitated or have incapacity or have, in fact, found to have committed gross misconduct, then the Judicial Conduct Committee will consider whether it is fitting to set up a tribunal. And then if the tribunal finds the judge guilty of such misconduct, then the tribunal will recommend that the judge be discharged from duty. Then in addition to that, a judge would have to go through the procedure of the 2/3 of the National Assembly voting on whether the judge should be removed from service and recommend that or pass a resolution to that effect, and it is for the president then to remove a judge. That's the procedures that would be followed to hold a judge accountable. But of course, the Office of the Chief Justice has already put in place mechanisms of accountability. One of them, some of them is, of course, we have a registrable interests now, where judges have to account for the financial position. We also have a situation where we have norms and standards encapsulate what would have initially have been a judicial code of conduct to which judges are held. And then we also have the Judicial Conduct Committee, where misconduct of judges are reported as complaints and various sanctions may be imposed. So to that extent, I would say there is judicial accountability.
Thank you, President. But
Thank you. Commissioner Matumela, if you still want to ask questions. Commissioner Malema.
Thank you very much, President. Judge, here would you agree with me that here we appoint honorable judges who behave in an honorable manner?
Yes.
Would you call the conduct as discussed between you and Judge Homu as honorable?
The conduct between me and Professor Motala.
No, the discussion, about that. You had a long discussion with Judge Homu. I don't want to go into it. No.
My response to Judge Homu's questions.
No, it's not. You discussed it with Judge
You
President
discussed
Homo.
your emails, SMSs, WhatsApps with Judge Homu now.
Yes.
And you have since apologized
Yes.
because you accept that that was not an honorable thing to do.
Yes, the content of my messages was not honorable, and I admit that it was not honorable.
And people who engage in a conduct that is not honorable, they are not honorable themselves. Do you agree?
I think that it depends on the nature of the conduct.
You apologized and said sorry because your conduct was not honorable. And you know that this body appoints honorable people. And therefore, people who engage in a conduct that is not honorable cannot be honorable themselves. Do you agree?
I cannot agree.
Okay. Do you think it is honorable and expected of a judge to discuss colleagues with friends and because this is a private conversation. We're taking what you are telling us. It's a private conversation between friends. You discuss your colleagues' judicial issues with friends. You think that is honorable?
What I found dishonorable was that, in fact, the friend was prepared to publicly criticize the judges without getting the judge's version of events.
So you are discussing the judicial matters with friends and you say you don't see anything wrong with that. I don't want to talk about your friends. I'm talking to you. He's not here. I'm talking about your conduct as a judge.
Now, I do see that it was wrong to discuss it with him. As I've said, I've learnt a lesson.
And therefore it is dishonorable.
It was incorrect.
And therefore you are dishonorable.
I can't say that I'm dishonorable.
Judge, you want us to lower standards.
I know. I would say that my remarks were intemperate.
Whatever you call it, it is unacceptable conduct of a judge who has applied for a senior position which has got everything else to do with leadership. You should have on your own just withdraw from this up until you have communicated and apologized to your colleagues and rework on your temper and your conduct, and then only then come back here. You don't think that was an honorable thing to do?
I can't agree.
You think we with our high standards here, we pitch very high here, we don't play. We pitch very high. With our standards here, we must compromise and appoint a person who discusses Chief Justice, who discusses colleagues with his friends and say, this is leadership which can control its temper and it is honorable and behaves in a manner that is acceptable in the judiciary. Should we say that after going through everything here, which you didn't deny?
I do believe that I'm not a person that is incompetent. I'm a capable person, and I'm a person with strong ethics and a passion for advancing the judiciary and transforming the judiciary.
My last point is that, do you accept that what you say in private you must be prepared to say in public? Do you accept that as a leader? Because you cannot take leave from yourself. You are a judge. Even when you retire, you are a retired judge. You can't take leave from yourself. So as you sleep or wake up, the posture you take in social activities, every conduct you display, private and public, you remain a judge. Therefore, in your conduct throughout, you should display such quality.
Yes, I agree.
And here you took leave from being a judge.
Yes, I became angry and tried to defend the judges.
And you failed as a judge.
I failed to contain my temper.
No, the judge failed to control the temper. Let's not run away from that. You are a judge. A judge failed to control the temper.
I failed to contain my...
The judge behaved in a dishonorable manner. You took leave from yourself. There are days where you just take off the gown and want to become an individual, and your profession doesn't allow that.
I think you've already placed that, Commissioner Malema, and she has responded. Even if you are not satisfied with that response, I think she has.
Let's thank the president.
Professor or Commissioner Ntlama?
Thank you, President. So, are you still going to sue, Professor, since this document has been made public?
No, he said he was going to go to the media with it. He didn't go to the media with it. He presented it to this forum. I have no intention of engaging in litigation with the professor or anyone else.
Okay, it's fine. Then let's come back to your office. If we do forgive you and give you the opportunity to become a judge, what is your opinion regarding the use of indigenous...
Sorry.
to become a DJP, yes. To become a DJP. What is your opinion regarding the use of indigenous languages, both as languages of records and communicating languages in the courts?
I think that it is certainly something that we should be implementing. Currently, we use interpreters, and unfortunately, a lot of meaning is lost in the translation with interpreters. I myself do not know and use an indigenous language, but I would encourage myself and others to learn one. But certainly, it ought to be a language that can be used in courts.
Thank you. Commissioner Nsebeza?
Thank you, President. Judge Allie, just for the record, 6 days ago, you asked the Secretariat to place before us the communications between you and Professor Motala in an email of the 31st of March, 2016. You remember that?
To place the emails of Professor Motala and me. The email in which he had already sent to the JSC.
You wanted the JSC to have sight of the communication between you and Professor Motala.
The letter which he had already sent, yes. I referred to that letter in explanation as to my view on the communication.
The answer is yes.
Yes.
And you expected, or you anticipated, or you should have anticipated, that the members of this commission would want to get into the details of what it was that gave rise to what you said. Please, would you be so kind as to ensure that the commission receives this response? You must have anticipated that we would want to know what it is, the full context and the full picture. Is that right?
Yes.
Now, I know you have apologized, and I know that up to this point, you have not considered that you should not continue to make yourself available for the position of DJP. Now, I'm just asking you, as a person whom I have known for a long time, do you think you should continue to make yourself available for our consideration for this position in light of what has happened in the last hour and a half or so?
Yes, I do.
Because you've apologized.
and made concessions that many of the allegations were made in the heat of the moment and in anger, and were incorrect.
Thank you. Commissioner Didiza.
Thank you very much. Good evening, Judge.
Good evening.
Yeah, I want to just ask you two questions in relation to your answer on the questionnaire that was put to you, point 17, which asks you about your contribution to the law and the pursuit of justice in South Africa. You have mentioned a number of things there that as part of a collective, namely NADEL, together with civil society, we lobbied for, succeeded in achieving the following, and you mentioned a lot of things there. And the second question relates to, maybe let me finish that. How did you do it? Maybe what was your specific contribution in those collectives?
Okay.
And the second question relates to 6, which is the subsection of 17, where you say, I addressed and attended several Women's Day events as a judge. So I would want to know, how does addressing meetings of Women's Day and events as a judge contributes towards law and the pursuit of justice in our country?
All right. Firstly, as part of the collective, I think my CV, which was attached, also sets out the various positions I held within NADEL and other civil society organizations that I've always worked within NGOs to achieve justice and equity and for all of the people of South Africa, to achieve access to justice. And I was referring to a time which was prior to 1994, when the lawyers' organizations such as NADEL were lobbying and making representations for the inclusion of certain rights and freedoms in a proposed constitution. I was part of workshops that were organized at the University of Western Cape and elsewhere with the ANC's Legal and Constitutional Committee and NADEL to debate the content of what the lawyers, the democratic lawyers at the time, felt should be included. I was part of lobbying for the abolition of the death penalty through NADEL. This is obviously all in a pre-1994 era. And also then we made representations to the Law Society and other organizations and to the Legal Aid Board to extend judicare, to ensure that legal representation is available to every accused person in our court. It's many issues that we now take for granted in the post-1994 era, which were not in existence then. And as part of this NGO and other organizations, we actually lobbied for these changes. And of course, many of these changes are now taken for granted as law, but they did not exist then. When it came to the recognition of customary marriages, I remember going along with a NADEL delegation to...
I'm sure that's sufficient.
Okay.
For what you have placed
Then
before us.
turning to the issue of the addressing and attending Women's Day events as a judge. When I arrived at the Western Cape High Court in the year 2004, I was only the second woman judge of color. The other woman judge of color that was there some of the time, but she was also working in the land claims court. So I was primarily the only woman of color in the division full time. And so when there was a need on Women's Day events to go and address, for example, the candidate attorneys of the Law Society, I would address them on how they ought to advance women in the profession and how they ought to, in fact, apply the law in a way to give access to the rights of women. I addressed the national prosecuting authorities, women also on Women's Day, on how they can best advance women's rights and women's rights as human rights. I consider those addresses to be contributions to the law and contributions in pursuit of justice as to how one, in fact, could encourage other role players in the legal profession to, in fact, advance gender equality and transformation.
Well, thank you very much. Thank you, Judge. I had thought, because, I mean, on the things, the reason I raised the question, the first question in particular, is because a majority of people in this room could claim the same, because they were part of the activist call prior to 94 that could have done all sorts of those things as part of various organizations. I thought maybe there was a specific thing that, in response to your question, you would have cited. Either maybe you drafted a paper, made a presentation, or you were serving in a committee during the negotiations process in CODESA, or maybe you were part of the drafters of the law that recognized customary marriages. So it was in that context that I was asking you specifically, when you talk about contribution, that it something that you would have pinned down for me, which is not part of what a majority of people, as I say, in this room would have been part of those activities as part of the collectives.
I accept that. My paragraph 1, under paragraph 17, says, as part of a collective, namely Nadal, together with civil society, we lobbied for and succeeded in achieving the following. There's a semicolon, and then there are all these subcategories. So it wasn't meant to convey that I individually did it. I'm sorry if it came across that way.
Yes, thank you. Commissioner Schmidt?
Thank you, President. I would like to put you just 3 comments made by the National Bar Council of South Africa, because it creates a negative impression. I'd like the benefit of your comment.
Yes.
But in paragraph 10.1, it, for instance, says, it is repeated that the candidate is at times fair and at times impartial. With regards to the candidate's independent-mindedness, it says, as a judge, the candidate has demonstrated a degree of independence. And then thirdly, with regard to your ability to conduct court proceedings, it says, the candidate has presided over many proceedings as a judge of the High Court, has demonstrated that she at times is able to conduct proceedings. Now that creates a negative impression, because it doesn't say at all relevant times or at all times, which one would have expected it to have said. So it creates a negative impression to the utmost degree, which I'd like you to comment upon.
Okay. Firstly, I have not been taken, none of my decisions or my proceedings that I presided over have been taken on review or appeal on the basis that I acted unfairly in proceedings in court. So to the extent that that perception is created by that organization, they have not followed through with any complaints to that effect. When it comes to my temperament in court, I, like all other judges, would have a certain temperament in judicial proceedings. In fact, in court proceedings, in fact, I would consider myself to be firm but fair, because I don't take lightly any attempts to derail court proceedings. So I support the idea, and I conduct my proceedings in a way, as I said, which does not allow for the misuse and abusing of the system. However, the temperament one has in court proceedings is very different to the temperament one must have as a deputy leader of other judges. There one is required, in fact, to deal with highly independent colleagues of different temperaments and styles, and one has to, in fact, deal with them in a way where one tries to gain their cooperation. And failing that, if one has to make management decisions, I will not squirm from making management decisions that are hard and difficult, obviously in consultation with the Judge President.
Just to conclude, President, and I don't want to juxtapose it against competing candidates, but in another instance, it is said that the candidate is known for fairness and impartiality of another candidate. And it's said, as a judge, the candidate has demonstrated a high degree of independence. Now, I'm just juxtaposing it because that candidate, I would suppose, finds himself or herself in the same environment as you do. And therefore, I'm asking you this question because it does create a negative impression.
I'm not sure that you'd like to comment or that a comment is expected of that.
I'm not sure either. Through you, President Party, perhaps you can tell me if I should respond.
It's fine. Thank you, Mr. President.
It was a comment to you. JP Khomo, just one little thing to deal
Yes.
with.
Sorry, Judge. Just one aspect, and I'm going to your questionnaire, page 8, paragraph 18, that's section 3, general. Are there any circumstances known to you which may cause you embarrassment in seeking the appointment for which you have been nominated? Now, these things have come out and you had not disclosed them. Is that a mistake on your part? These things that have come out in the WhatsApp, the SMSs, the emails, should you not have disclosed them?
Judge President Khomo, at the time when I completed this questionnaire, 2 years had lapsed since Professor Matala and I had our heated debate and argument. I asked him not to disclose it in the media. He didn't do so. I assumed the matter had gone and been laid to rest. I did not consider it to be an issue that ought to have been in the public domain. I thought it was a private argument, and so I did not disclose it for those reasons.
Sorry, Judge. I didn't want to go there because, you see, my problem is if you did not disclose this thing and you were appointed and then they come out, that is the reason, then you'll have to be hauled before us with all these things. That's why if you belong to a secret organization, you have to disclose. Now, I'm just asking you, and I'm going to not follow up, should you not have disclosed this? Is it not an error of judgment on your part not to have disclosed this on your own? As this form says disclose.
Yes.
Anything.
Yes, in view of the questions that have ensued here and the way it was dealt with, I ought to have disclosed it.
Thank you, Judge Ali.
Thank you.
You're excused.